Hello, everyone. Sorry for the delay. We were just allowing everyone to get on. I just want to welcome you guys for attending. And thank you for joining us virtually this afternoon for what we hope will be an informative presentation for landlords and tenants in the city of Richmond. My name is Cynthia Shaw, and I am the administrative analyst for the Richmond Rent Program. Staff attorney Charles Ochanuga will be conducting the presentation this afternoon. Before we get started, I would like to share some logistical information. Please note that this presentation will be posted on our website at richmondrent.org/workshops for your reference, and it will be posted after this webinar. Please also note that this presentation is being recorded, and we hope to post the recording on our webpage as well. If you have any questions on a particular topic discussed today, we ask that you type your questions into the question and answer function on the bottom of your screen, and we will address your questions at the end. If you called in via phone, you can unmute by pressing *6. The host will have to allow you to speak though, if that's the case. But I believe today we're just doing question and answers. I will read your question, and our staff attorney will address your question. Okay, so without further ado, I would like to introduce Charles Ochanuga.
Thank you for that. Thank you for everyone's patience. Similar to this COVID-19 state law expiration, it feels like the walls are closing in, and if you don't act soon, things will fall apart. But just as we demonstrated, this was a little bit of a microcosm. Let's be patient, work together, we can figure it out. So we do have interpretation, and I respect your time, but I also respect the need of the segment of our population to be able to access the information in a way that's meaningful. All right, so this, as you all know, is going to be a discussion around the expiration of COVID-19 state law and non-payment of rent evictions. The reason why this came about was that we've received numerous inquiries, calls, emails, etc., as to what exactly can I do? Can I evict, or will I be evicted after today? And so hopefully this presentation provides you with information that empowers your decision-making. As I'm sure you're all aware, I'm an attorney, but I'm the attorney for the rent board. I am not the attorney for any one individual, nor am I the attorney for you all. And so I cannot provide you with legal advice. I can only empower you by giving you information. So hopefully that's what this does today. When I put this together, I was hoping that it would be less formal, more informal, and that there would be adequate time for you all to ask questions that you might have. We've built in time for that. So despite the delay, don't worry. If you have enough time to stay on past 2, we'll still be here. You can ask me whatever questions you might have. You might be a little bit disappointed in some of my answers because I am not going to address your specific case. I will just I will address the generalities. For instance, can I evict my tenant? Likely, I will say there are certain circumstances where a tenant can be evicted, or can my landlord evict me? I will say there are certain circumstances where a landlord can evict you, and then I will lay out those circumstances. But it's your job to apply your set of facts to the particular circumstances laid out to make an informed decision. Lastly, if you take anything away from this discussion, please speak to an attorney if you're unsure. This law is extremely confusing. I didn't write it. The city of Richmond didn't write it. You can blame your state legislators for that one. And rental assistance is the crux of whether or not you will be able to defend against an eviction, or whether or not your landlord can evict you. It is going to really, a lot of it will turn on the rental assistance aspect. Next slide. All right, so back one slide. All right, so I'm going to give you a quick overview of rent control and eviction protections in Richmond. It's going to be extremely quick, but it's kind of necessary. So next slide. So just bear with me. I'm going to make it really fast. You already probably know there's just cause in the city of Richmond. Most rental units have just cause attached to it. And that means that there are only 8 bases for which you can evict your tenant or that a tenant can be evicted. Many of these bases have been temporarily suspended because of the Richmond Eviction Moratorium. And that's why I think this slide is important to let you know, yes, sure, there's 8 ways a tenant may be evicted. However, currently you can only do 3 ways under the eviction moratorium in the city of Richmond, which I will get to shortly. Next slide. For those individuals looking to evict or defend against an eviction, just know that in the city of Richmond, in order to evict, one of the things that a landlord has to do is that they have to plead and prove that they're in compliance with the rent ordinance. And that means that they fully paid their fees, they have registered and or enrolled their property and any other kind of requirements. So it's important for landlords to know that if you want to pursue an eviction, even if it's related to rent, you're going to have to be in full compliance with the program, and you can shoot us an email or a phone call to determine whether you are, so that you can proceed. Next slide. Finally, real briefly, this is a Q&A session, but we do offer a comprehensive counseling around the rent ordinance, relocation ordinance, and state law. We also offer referrals to community legal service providers, landlords. For those of you who are landlords or owners, this is really important. The contract we have allows a landlord and a tenant who qualifies, and the qualification is on income. Those individuals who qualify can access free legal advice through a legal clinic that's provided. So just FYI. And we obviously offer a tons of different kind of services. This is just a very brief overview. Next slide. All right, and we're going to quickly go over local and state laws that pertain to COVID-19 evictions. Next slide. I see a question. I'm not going to address questions until the end, but I will address that question. I am unsure. I'm hoping that it will be translated. It should be, but that's up to the executive director. But believe me, I think we will be working on something like that. So the City of Richmond urgency ordinance, which I just mentioned, is still in effect. It's in effect until the end of the local emergency. And the local emergency is declared by I believe by the city manager. And to my knowledge, there hasn't been a declaration of the end of that local emergency, so it's continuing. And even when that local emergency is declared over, it continues 60 days thereafter. So the eviction moratorium in the city of Richmond is still well and alive. Next slide. And just as I mentioned before, next slide. Just as I mentioned before, currently, your landlord only has 3 bases to evict a tenant. That's if there's a nuisance that poses an imminent health or safety threat, the tenant has failed to pay rent, or the landlord wants to engage in an Ellis Act eviction. Next slide. Okay, and so this is what you all are here for. It's the COVID-19 Tenant Relief Act. I'll often refer to it as the CTRA. It's just a lot shorter for me. I'm going to give you a little bit of background and then start getting into what this is all about. So, and this part's really not that important. It's just to orient you again. I'm sure you're all familiar with it because you've all experienced it, but just for those who are less familiar, last year in August, the governor signed a law that essentially prevented evictions, that rent-related evictions when COVID was at issue, that occurred when the debt occurred between March 1st of 2020 and January 31st of 2021. Now, after that law expired, they passed another law to extend it, and that extended it to June 30th of 2021, and then they passed another law to extend that law, and that extended it until today. And that's how we're here. And after 3 extensions or 2 extensions, they said, enough is enough. We'll let local jurisdictions figure it out. And, Richmond, the city of Richmond, some cities, I will just say some cities like Oakland have an eviction moratorium that includes rent-related evictions. Cities seem to be empowered to do that kind of thing. And so the state just decided we've stepped in longer than we need to. We're going to leave it up to cities to figure out their next steps. So here we are. Next slide. All right. So under the COVID Tenant Relief Act, a landlord can't evict a tenant for non-payment of rent that became due between March 1st of 2020 and August 31st of 2020 if the tenant returned a declaration of a COVID-19 related financial distress to the landlord. Now, you already know that, right? And that's kind of part of the law that's set to expire today, but it still has implications going forward. And I think that's why I've mentioned it, and that's why it's important. And I'm going to tell you what those implications are shortly. So getting through the rest of this, likewise, if there was a non-payment of rent debt that accumulated between September 1st of last year and today, September 30th of 2021, if the tenant returned to the landlord a COVID-19 related financial distress and paid 25% of the total rent due by today, a landlord may not evict them. Again, the same thing as I said before, that has implications going further. And the law, as well as the messaging, encourages tenants who were experiencing a COVID-19 related financial distress, but did not receive a notice of termination of tenancy, to provide their landlord with a declaration so that the landlord would be on notice that they had a COVID-19 related financial distress and pay the landlord 25% where applicable. Next slide. So the CTRA, the COVID-19 Tenant Relief Act, remember the CTRA is set to expire today. So what happens next? So despite the expiration, and I understand it's extremely stressful, and rightfully so, because I don't think the state has provided terribly clear guidance to both landlords and tenants as to what's going to happen. And you really have to dig into the law to really understand the obligations and the rights of both parties. So I totally understand where the confusion is and the stress is. I will say, though, that there are despite the law expiring, there's 2 major principles that will still apply going forward. And those 2 principles are past actions under the CTRA prevent future evictions, and I'll explain that next. And the second principle is it's all about good faith efforts to obtain rental assistance. Next slide. So I've mentioned before that if you owed rent between March 1st, 2020 and August 31st, 2020, and you had a COVID-19 related financial distress, you gave your landlord a declaration, or the landlord received a declaration. As to that, the landlord could not evict. Now that prohibition is permanent. What that law has done is it has removed the grounds for eviction when those things have been satisfied. So let's just say November 1st, 2021, a landlord wants to evict a tenant for rent owed the rent that was owed in May of 2020, right? Well, if the landlord had received the declaration within the requisite amount of time related to that rent, the landlord can no longer seek it. The landlord can no longer evict based on it. The landlord certainly can seek the rents owed. They can go to small claims to do that starting November 1st, but they can't evict based on those rents for the very reasons that I stated. Same thing during the transition period. That's rents that occurred between September 1st of last year and today. If the landlord received a declaration of a COVID-19 financial distress and the tenant paid 25% of the total rent due or owed, that basis for evictions is just eliminated. The only way the landlord is still able to seek the monies owed in small claims, but the basis, the rent, the unpaid rent cannot form the basis of an unlawful detainer. All right, next slide. So just stepping away, so just to put a button on it, if landlords and tenants, if there was a declaration exchange and 25% of rent paid during certain periods, you may have an issue with your eviction. Just please bear that in mind. And if you have any confusion around that, please ask me questions after this discussion, and obviously follow up with an attorney so they can actually break it down to you and give you legal advice. So moving on to the second thing that the CTRA does going forward is it places, I say great, but it really places extreme emphasis on a landlord's need to seek rental assistance. That in fact, from October 1st, that's tomorrow of this year, October 1st, 2021 to March 31st of next year, if a landlord is seeking to evict a tenant for any COVID-19 related rents owed between March 1st of last year and March 31st of next year, the landlord has to satisfy these following requirements. So let me just restate all that. If you're trying to perform an eviction from tomorrow to March 31st of next year, and that eviction relates to rents owed that accrued during March 1st of last year and March 1st of next year, and there's a COVID-19 related financial distress there, you're going to have to satisfy the following requirements. Next slide. All right, so I broke it up into 3 parts, and I know this is how the law is written. It's not very clear, so I apologize. I try to organize it the best way I could, but there are kind of 3 parts to this. So first, if a landlord is just seeking rent that becomes due between tomorrow, October 1st, and March 31st of next year, so forget about all the rent from today backwards. That's not what we're talking about right now. Just put that aside for now. If a tenant owes rent between October 1st, 2021 and March 31st of 2022, a landlord has to provide at least a 3-day notice to pay or quit. And the notice has to include all of the following, right? So the notice has to include the time period in which the tenant may pay the amount due or deliver possession of the property. The notice has to include the amount of rent demanded and the date each amount became due. The notice has to include the telephone number and website address of pertinent government rental assistance programs. And finally, the notice has to include this verbatim language from the state's COVID-19 rental relief plan, as stated in the Civil Code of Procedures. I gave you the citation. I didn't copy and paste in the verbatim language because, quite frankly, it's a lot of language and it would be multiple slides, but you can certainly look it up. It's in that Civil Code of Procedure section I have right there for you. So your notice has to include all that if you're seeking to evict a tenant based on failure to pay rent that has occurred between those months that I mentioned, October 1st, tomorrow, and March 31st next year. So what about the rent that became due before October 1st, right? So the rent that's due today, looking all the way back to March of last year. What about that rent? Well, aside from the rents, aside from the rents that you've received a declaration on, and or received both a declaration and a 25% payment by today, aside from those, because remember, those bases no longer exist. You can seek the amounts in small claims, but they're not going to form a basis for, okay, I apologize. I'm speaking faster than the interpreter, so I'm going to slow it down. My apologies. But if you are receiving, if you're seeking to evict for rents owed, okay, you can't hear me. Can you hear me better now? I just want to make sure we do this. Okay, great. Sorry about that. I'll make sure I speak up as well. All right. So what about rents that became due before October 1st, 2021? No worries. So if you're looking to evict on rents that became due before October 1st, 2021, aside from the principles we've spoken about before, where you've received a declaration of a COVID-19 financial distress, and or a declaration and a 25% payment of the rents owed. Aside from those, because remember, those cannot form the basis for the eviction, you can seek the other rents, but it's very unclear whether or not you can serve a tenant a 3-day notice for those past rents, or if you're still required to serve a 15-day notice. I have here that before proceeding, you should consult with an attorney for legal advice. Of course, I formed my own opinion on what the law says. However, not only is this state law, which kind of prohibits me from interpreting it, I can only really provide you with the information. I can't interpret it. I'm also prohibited, as I said in the beginning, from providing you with legal advice. So whether or not you have to serve a 3-day notice or 15-day notice, I encourage you to please consult with an attorney. There's a lot of attorneys that do free legal consultations. You should reach out. And again, we do have a referral service that could, if you do qualify, would refer you to a clinic where you can obtain legal advice. And finally, the notice must be in a language the lease contract was negotiated, if negotiated in a language other than English. Next slide. Now we're, okay. All right, so regardless of whether a landlord is seeking to evict for rent accumulated on, before, or after October 1st, 2021, a landlord must file with their unlawful detainer complaint one of the following. So it doesn't matter if you're seeking to evict based on failure to pay rent that accrued from March to whenever, so long as it's accrued from March till March 1st, 2020 to March 31st, 2022. When you file an unlawful detainer, you also have to file one of the following. I'm not going to read it verbatim. It's up there and it will be on the website, but you have to file a statement that verifies under the penalty of perjury that you've applied for governmental rental assistance and a copy of a final decision that you received from the pertinent government rental assistance program denying a rental assistance application. Apologies. So again, you have to file a statement verifying under the penalty of perjury that you've applied for rental assistance and a copy of the final decision denying you the ability to receive that rental assistance, right? So that's one of the options that you can attach with your unlawful detainer when you go to court. Next slide. The next, if that's not available to you, here's an alternative option that the law allows you to do. So when you go into court and you're trying to file that unlawful detainer, you may attach a statement under the penalty of perjury verifying all of the following are true, right? So first, before you filed that unlawful detainer, you submitted an application for rental assistance that asks for all the rents owed under your notice of termination of tenancy. 2, 20 days have passed since the latter of either the date the landlord submitted the application or the date you served the tenant the 3-day notice, whichever one is later. 3, the landlord hasn't received notice or obtained verification from the government rental assistance program indicating that the tenant has submitted a completed application for rental assistance. 4, the landlord has received no communication from the tenant that the tenant has applied for rental assistance. Now, again, I'm just going to paraphrase, and I encourage you to look at the law so you can get a very thorough understanding of this all. This is obviously an overview, but again, as I said in the beginning, rental assistance is highly stressed under this law. And a landlord who seeks to evict a tenant will not be successful if they fail to do these things. And as you can see, they're really putting the onus on the landlord to make a good faith effort in obtaining rental assistance. But not only that, if the landlord's on notice that the tenant is seeking rental assistance, that may be problematic as well for the landlord in terms of satisfying the unlawful detainer requirements. Next slide. Okay, so again, when you file a complaint, you can either attach a statement under the penalty of perjury, claiming that you've applied for rental assistance and you were denied, and you can attach the final order from the governmental assistance program denying you that. Or your second option is what we just explained in the previous slide. I'm not going to go back over it, but all those things I just mentioned. And your third option is you can just attach a statement under the penalty of perjury that the rental debt demanded from the tenant in the complaint accumulated under a tenancy that was initially established as defined by the law. And what does all this mean? This simply means that if you have a new tenant as of October 1st, if you have a brand new tenancy, no leftover tenants, a full turnover, right? Like all the people in your unit were not people were not in your unit prior to October 1st. That's what it's very clear. The law is very clear on this. If there's a full turnover, then all you need to do, if your tenants fail, your brand new tenants fail to pay you rent, when you file down a unlawful detainer complaint, you need to attach, or you may, not that you need to, you may attach a statement under the penalty of perjury that the rental debt demanded from the tenant accumulated under this new tenancy. All right. And we'll see what happens, but the law requires that your statement under the penalty of perjury be made on a judicial counsel form, if necessary. We'll see if the judicial counsel actually creates a form. There's a lot of forms being promised by the state that weren't really delivered on. So we'll have to see how that works. But I imagine the reason being is that there is very stringent, strict language on their form that if it's found that your statements are purposely false, it can open you up to, it can open a landlord up to a lot of liability. Next slide. Okay. So whichever option you choose, whichever option a landlord chooses, 1, 2, or 3, the landlord must serve the tenant with copies of the statements and final decisions that were filed with the court. So pretty much everything you file with the court, serve it on the tenant. Because if you don't, the law is clear. You will, the landlord will lose their case. So landlords out there, make sure everything you serve with the court, give it to the tenant. If the tenant now has an ability to challenge what you've given them. They can argue that perhaps 20 days haven't passed since you've filed that rental assistance request application, or that perhaps you hadn't done it at all. Whatever argument they have, a tenant can raise those issues. And if a tenant raises those issues, then a landlord carries that additional burden of proving that before filing the complaint, the landlord completed an application for rental assistance to cover all the rent that's asked for in the complaint, and the landlord was denied because of lack of eligibility, lack of funding, or the application remained incomplete due to the tenant's failure to properly complete the portion of the application that is the responsibility of the tenant within 15 days. Next slide. So again, I will just reiterate, a lot of this will come down to a landlord's efforts to obtain rental assistance. And this is probably very important. I know we've received questions on this, but if there is debt that accumulates between October 1st, tomorrow, and March 31st of next year, in order in order for a tenant to prevent an unlawful detainer judgment, that the tenant would have to have paid the landlord all the money owed, not 25%. It's going to be all the money owed. And just bear that in mind. Now that payment can come in a form of a third-party payment, right? For instance, rental assistance can pay a portion of it. But regardless, the landlord must be made whole before that unlawful detainer will be prevented. And that's in the law. Next slide. So what about the tenants, right? We've been talking a lot about the landlord's obligations to have to seek out rental assistance. What does the law say about a tenant's obligation? Well, the law makes it optional, right? Whereas the landlord has to do something, the tenant may file for a rental assistance. However, if the tenant files for rental assistance, the tenant gains benefits. They gain defenses against an unlawful detainer. So long as the tenant is still in their rental unit, the tenant may apply for rental assistance and stave off an unlawful detainer, a judgment, or even a writ of possession. That's important. So if a landlord goes through this whole process, all right, and has a viable basis for evicting the tenant for failure to pay rent, and they go to court, there's a whole argument around it. The judge says, you know what? No, the landlord's correct. Tenant, you failed to pay rent. This case is over, you lose. Well, then what the judge does is the judge issues something called a writ of possession, which is essentially an order for the sheriff to remove the tenant, right? And the sheriff usually comes, I don't know, maybe 10 days in this county, maybe 14 days. It might depend on their schedule. If the tenant files for rental assistance, the judge has to pause the sheriff from coming out and removing the tenant, so long as the tenant's still in the unit. If the sheriff has already removed the tenant cannot avail themselves to this benefit. But if the tenant is still in that unit, the tenant may still have a way to retain possession of that unit. Next slide. Okay, so seeking rental assistance will provide tenants with a defense from a rent-related unlawful detainer, where the complaint for the unlawful detainer is based on a demand for payment of rental debt that accumulated due to COVID-19 financial hardships. Okay, that's number one. Number two, the tenant submits verification to the court that a government rental assistance program has approved an application for rental assistance for part or whole or all of the rental debt demanded in the complaint. And three, the approved payment for rental assistance together with any additional payments made by the tenant constitute a full payment of the rental debt demanded in the complaint. So again, if the sheriff is on their way out, maybe they come the next day and this tenant has applied and has been approved for rental assistance, the tenant can go to court and file a motion for relief based on this approval, and the judge must suspend the sheriff from coming out. Next slide. And that's exactly what I said here. You should also note that this can occur at any point during the unlawful detainer. So, if your trial for an unlawful detainer is set for the following week, and before your trial occurs, a tenant has now received an approval for rental assistance, the court must pause your trial. They're likely going to have to continue it and have a hearing on some of the issues related to the rental assistance that I'm going to talk about. Okay, so once the court has received verification that there's a rental assistance application that's been approved, the court will rule on one of the following ways. If the tenant does not qualify for relief, the court just denies the application, and you can use that denial. A landlord can use that denial in any unlawful detainer action between the parties. If the tenant qualifies for relief and the plaintiff, the landlord, have received all of the payments, then the court shall grant the application and set aside any judgment or dismiss the case, right? So long as the tenant has qualified for rental relief, it doesn't matter where you are in the process. If the landlord has received the payments, all the payments owed, the court must dismiss the case. And vice versa, if the tenant does not qualify for rental assistance, then that doesn't have any impact on their case. And if the landlord prevails, then the landlord obviously prevails. But of course, the law is never that clean, right? So what if the tenant qualifies for rental assistance, but the landlord has not received any payment? Next slide. So if the tenant qualifies for relief and the landlord has not received all of the payments, the court must do the following. They set a follow-up hearing to be held within 15 days. They extend the stay. That the stay just means pause. So whatever they've paused, they continue to push it back through the date of the follow-up hearing. Meaning that, if you had a trial the following week, that trial needs to occur after the hearing occurs on the application for rental assistance, right? And then finally, the court extends the stay, that means the pause of the execution of any writ of possession in the case through the date of that follow-up hearing. So if the sheriff was gonna come out tomorrow, but this application has been received by the court, that the tenant has been approved, the court puts a pause on the sheriff's ability to come out and remove the tenant. And if the landlord hasn't received all the payments under the application, the court sets another hearing for 15 days out and just extends the pause on the sheriff eviction until that hearing has occurred. Next slide. So at the follow-up hearing, the court must issue one of the following orders. If the government rental assistance program has withdrawn their approval of rental assistance, then the court shall deny the application. So if the tenant was approved at some point, but after a follow-up hearing, the government rental assistance program has determined that, in fact, the approval was erroneous, the tenant loses their case. If the I'm sorry, I should rephrase that. It's not that the tenant loses their case, it's that the landlord wins their case, that they ultimately prevail and they're able to evict the tenant. If the plaintiff has received all the payments, then the court shall grant the application and set aside any judgment and dismiss the case, right? And remember, this is the follow-up hearing. This is the second hearing after 15 days. If the government rental assistance program has not withdrawn the approval of the rent assistance, but the landlord has not received all the payments because the rental assistance program has not yet issued its part of the payment, then the court shall order another follow-up hearing. All right. And so again, they're just pretty much the court's going to wait until the rental assistance program is able to pay the landlord their portion of the payment. Now, if the government rental assistance program has not withdrawn their approval, that means the approval is still good, but the landlord has not received all the payments because the tenant has not yet paid the tenant's part of the payment, then the court shall deny the application with prejudice. All right, so it's important. So just to kind of summarize it all, if a tenant applies for rental assistance and a tenant is approved for rental assistance, there has to be a hearing, right? So long as they submit verification of that approval to the court has to set a hearing. I don't have it here, but I believe the hearing has to occur within 5 to 10 days. All right, and what the hearing is going to determine is whether the amounts that the tenant was approved for satisfied the total amount owed according to the complaint, right? And whether the landlord has received all the money owed. Okay, if the landlord hasn't received all the money owed, and that's because the rental assistance program has yet to disperse that money, then the hearing will be continued for 15 days to check back in to see whether or not the disbursement has occurred within 15 days. And again, if the landlord still hasn't received it, another hearing is set, right? All the while, the rest of the case has been paused. Everything's put on hold until the court can figure this one thing out. Now, sometimes you apply for rental assistance and the rental assistance program will just give you a portion of what's owed. Maybe your debt's too large or maybe you simply just don't qualify for the full amount. If that's the case, then the tenant has to pay a portion of the rent owed. And the law's not fairly clear on this, but so I would, for tenants out there, you should seek legal advice, because it seems as though that prior to the first hearing on your verification of your application for rental assistance, the court's going to look to see what portion the tenant's responsible for and whether or not the tenant has satisfied their responsibility. And the law also seems to suggest that the court has a discretion to say that, well, even though the rental assistance program can, will, and is able to satisfy their portion of the payment, if the tenant has not satisfied their portion of the payment, they lose. And we move on and to trial if it has not happened, or if the eviction has already occurred, then the sheriff can remove. So, next slide. And just last slide on this is just some of the rental assistance resources that we know of. Next slide. If they're on our website as well, I really encourage everyone. It's difficult. I don't underestimate what any one of you are going through. It's difficult, but I really encourage all of you to seek out the rental assistance, regardless, right? I mean, it's important that landlords receive what they're owed, and it's important that tenants receive the help they need to remain housed. And here are the 6 various organizations, government organizations that are able to at least take an application and review your application. And again, as a carrot or a stick or both, the law really centers almost all of your unlawful detainer evictions that are related to rent. They centered that around your good faith efforts to have sought out rental assistance. And with that, again, I apologize if it was a bit longer than needed, but I thank you for your time and I welcome your questions.
Okay, thank you so much, Charles. Can you guys hear me? Can you hear me, Charles? Let me make sure.
I can hear you.
Okay, so thank you so much. So we do have a few questions. Some folks have been typing in the question and answer Q&A box, and we've been responding live to them as you were presenting. So some of the questions have been answered, but we do have some questions. I'm going to read out the question and then Charles will answer it.
Before you read out the questions, I'm sorry. Before you read out the questions, what I should have said is, like I said, I don't provide legal advice, and obviously that you all know that, but I also don't answer comments that aren't questions. So please have a question. And in the legal world, we call that argumentative. It's a comment that doesn't seek an answer. If it doesn't seek an answer, it's probably not going to be answered. All right,
Okay.
Go ahead.
Sure, no problem. The first question is says, what active approach is the Richmond Rent Program doing to encourage their constituents to be responsible for paying their rent beside a rent relief program?
I don't understand the question, and you feel free to retype it, and hopefully I can understand it. Also, try to limit your questions to the topic of the presentation, but feel free to retype that question, and we'll get to it when we get to it.
Okay. The next one is, on average, ERAP is taking 2 months for landlords to get payment. Does that mean the court must wait as long as necessary to hear on approval of relief?
No, I think option 2 that I had in the slide, I'm going to see if I can pull it up.
You want me to go back?
Yeah, but I'm gonna see if I can give you the slide number. All right, it's slide 16.
Okay.
Okay. So remember, when you're seeking your rental assistance, when you're filing your unlawful detainer complaint, you have to attach one of three things, right? And this is the second thing you might be able to attach. And it's a statement under the penalty of perjury verifying the following, that, and I'm going to paraphrase, that you've actually went and submitted a completed application for rental assistance to a government rental assistance program that covered all the debt owed, and that 20 days have passed, right, since you did that. And again, the days are measured in a certain way. So this is a paraphrase. You want to look to see that you satisfy that 20-day mark. But 20 days have passed, right? You haven't heard anything from the rental assistance program, and you haven't received any notice either from the tenant or the rental assistance program that the tenant has themselves sought rental assistance. So to answer your question, it's unlikely you're going to have to wait, a year or something until you get a final order. If you don't qualify under the first thing you could do, you can go to number two, like we have up on the screen, and you can make the argument that you're able to proceed because 20 days have passed and you sought out rental assistance, you haven't heard anything back, and the tenant and you haven't had any notification as to the tenant seeking assistance themselves. Okay.
Okay. The next question is, what if they just stopped paying rent and has not applied for any rental assistance and will not respond to any correspondence?
Yeah, so generally, again, as a general matter, you're able to evict a tenant for non-payment of rent, generally, right? If the rent that you're seeking to evict on was subject to a declaration, which means that the tenant at some point gave you a declaration saying, hey, I have a COVID-19 financial related distress issue and that's caused a non-payment of rent, then those grounds, that basis is gone. However, if you never received any, if the landlord hasn't received any declarations and where applicable hasn't received that 25% payment, and the tenant has failed to pay rent and there's no rental assistance there, so long as the landlord satisfies all the requirements, that's just not the state law requirements, that's, the paying the fees for the program, for the rental program, and enrolling the property, doing all that stuff, as well as seeking in good faith rental assistance, then the landlord, has a basis. And the court, obviously I can't determine whether or not your eviction will be successful, but you're on better ground. I'll let you know that. Just remember too, if a tenant is just disappeared, they're just like, well, AFK, away from the keyboard, and they are non-responsive, the landlord still has an obligation to seek rental assistance, still has that obligation. So that's not going to get rid of that obligation. Next question.
Okay, next question is, when can landlords raise rent?
A landlord, well, this is not part of the presentation, but I will address it. The rent moratorium, the rent increase moratorium, which is the pause that was placed on rent increases, was a county-wide moratorium passed by the county. That moratorium is gone. Richmond's current moratorium does not have a rent moratorium. It only has the eviction portion of it. So if a landlord qualifies, and I'm going to be really clear because I don't want anyone here to say, Mr. Oshanuga said this. I'm going to be very clear. If a landlord qualifies otherwise under the rent ordinance, that means that they're full compliance with the rent ordinance, and they have served their tenant with the requisite notice, whatever time period that might be, they could take an AGA so long as it's an AGA. And an AGA, I'm sorry, stands for an annual general adjustment under the rent ordinance. And I'm not sure, and that's only for rent controlled landlords. For non-rent controlled landlords, obviously we don't control your rents.
The next question, since Richmond has no date to end the moratorium, we can't file for eviction?
Give me 1 second. There's apparently was a question asked earlier that we might have skipped over. I don't see it.
No, we're fine. We actually, was it in the chat you talking about? We actually answered.
Okay. Since the Richmond, can you say this again? Since the Richmond has no date to end the moratorium. No,
Since Richmond has no date to end the moratorium, you can't file for eviction?
That's incorrect. So remember, Richmond's moratorium prevents most evictions, but not all evictions. In fact, during Richmond's moratorium, we still receive notices for evictions. Evictions are still happening, but those evictions have been limited to Ellis Act evictions and nuisances that cause an imminent health and safety threat, right? Or a threat to health and safety, an imminent threat to health and safety. Apologies. The rent and the Richmond rent moratorium does not cover rent-related evictions. So that means you just simply must comply with the just cause requirements for evictions under the local law and the state law requirements for rent-related evictions as presented here.
Okay, the next question. So real quick, let me make a quick announcement. For folks who have questions, please enter your questions in the Q&A section at the bottom of your screen. That way we can answer your questions in the order they are received. If you're putting your questions into the chat, it's going to be hard for us to accommodate you in the right order is received. So please just enter your questions in the Q&A section, please. The next question is to confirm Richmond's eviction moratorium remains in effect after today, but it does not prevent eviction based on non-payment of rent. And is that because of the state moratorium?
Oh, yes, good question. Okay, yes. So just to be clear, Richmond's eviction moratorium still applies today, right? It will continue to apply until the end of the local emergency. Okay. So yes, it still applies today. And I think the second part of your question is, it doesn't apply, that's correct, it does not apply to rent-related evictions. There's a carve out for that. And that's not because of the state law. That was actually a policy decision that the politicians or council members made. And I think the question is really good because it highlights a point that might be unclear. As many of you landlords and tenants know, things change fast, right? And they change significantly. One day you can do something, the next day you can't, and then vice versa. And everyone's confused, and I understand that. You should know that it's not because of the state law moratorium that the Richmond moratorium carved out rents. That was just their choice. Other cities included rent-related evictions in their moratorium, which means in some cities, you can't even evict for failure to pay rent, all right, under their moratorium. Now, it's a political decision. Richmond may be able to just keep your ears close to the ground. I'm not sure, I don't work on that side of the city, so I'm unsure, but you should all know that they could consider the issue of bringing rent-related evictions into their existing moratorium, which is another way to say they could suspend rent-related evictions under their police powers. So good question. Next slide. Our next question.
Okay. If we applied for rental assistance and the tenant does not answer any communication, then disconnected their numbers and no email, can we then evict for non-payment?
Can you go to the prior slide that I have up?
Sure.
Was it this slide? Go to the, I'm sorry, can you go back to the other slide? Okay, I'm gonna be clear. I'm not gonna answer specifics, right? There's a lot of detail in that question, and it's probably because you're going through that, and I'm sorry you're going through that, but I'm not gonna answer that specific question, but I will give you information generally to help you answer your question. So if you're gonna file that unlawful detainer, you have to file with the unlawful detainer one of the followings, right? And we went to 1, 2, and 3. We're gonna focus on 2. Okay, so with your unlawful detainer, you have to file a statement under the penalty of perjury, verifying that all of the following are true. That before you filed your unlawful detainer, you submitted a completed, not a partially completed, a completed application for rental assistance to cover the rental debt demanded. That 20 days have passed since you did that, and I'm paraphrasing too, please understand that. So look at the law to understand how to measure the 20 days. That the landlord has not received notice or obtained verification from, from the rental assistance program, indicating that the tenant has submitted a completed application for rental assistance to cover the rental debt demanded. And the landlord has received no communication from the tenant that the tenant has applied for government rental assistance to cover the unpaid rental debt. If all of that is true, right? If you verify all of that in a statement, the law says then you may proceed. Will you win? Will you evict? Will you be able to evict? I have no idea. I don't know any other defenses. I don't know, and bear in mind, a tenant can disappear on you and be gone, and you serve a notice, non-payment notice and an unlawful detainer, and you follow all these steps, and you're very careful, everything looks good, and the tenant appears in court, and they tell the judge I filed, that they themselves have filed for rental assistance and that they were approved. Well, again, like we said earlier, the judge has to pause your case and determine whether or not that approval will lead to to the landlord's full compensation. So there are so many different things going on. So again, I don't answer specific questions. I'm not going to tell you you're able to evict. What I'm going to tell you is these are your requirements. And if you adhere to the law, most likely the law will respect your decision. Next slide. Next
question. It's okay. You're used to saying it. So I'm clear. A landlord is still required to apply for rent relief for a tenant after October 1st to proceed with an unlawful detainer for rent for the month of October.
Yeah, so can you go back, I think 2 slides maybe? Do I want that? No, next slide on that one.
The 13?
No, 15.
15.
Okay, yeah, so like in this slide, regardless of whether or not you're seeking to evict for rents accumulated on, before, or after October 1st, you have to file those statements. Now, I will tell you that the statements, that this requirement is for whenever there's a, actually, I'm gonna leave it at that. Let me see who asked that question.
It's under answered.
So whoever asked that question, I'm going to get back to you in a brief second, because I want to make sure I give you the actual law on that.
I can give you his name. Would you like the name, or?
Just highlight it for me. And then before the session's over, I want to say it to the group, so everyone, because multiple people might have that same question.
Okay, sure. Okay. All right, the next question is, so the facts are, tenant post October 1st must pay 25% of rent and submit a declaration if they are still impacted by COVID and can apply to ERAP?
Tenants must pay 25 and submit a declaration.
So the facts are, tenant post October 1 must pay 25% of rent and submit a declaration if they are still impacted by COVID and can apply for ERAP, ERAP.
I don't really understand the question. What I will say is that post October 1st, a landlord needs to be made whole in order for that eviction to be prevented, and that the 25% requirement ends today, September 30th. And yes, a tenant can always apply to rental assistance. I'm not sure if that answers your question. I'm sorry. If you want to rephrase it. back into the Q&A, maybe we can readdress it in a way.
Okay. Well, let me read the next question. Maybe
Oh,
you'll
before you do,
respond. Oh,
before you do, I want to go back to the prior question.
Okay, sure.
And
You want me
do
to
you
read
have the
it?
prior question in front of you?
Yes.
Okay,
It
go ahead.
says, so I'm clear, a landlord is still required to apply for rent relief for a tenant after October 1 to proceed an unlawful detainer for rent for the month of October.
Yeah, okay, so I'm gonna just read the law. It says on or after October 1st, which is tomorrow, and before March 31st of 2022, in an unlawful detainer action pertaining to residential real property and based in whole or in part on non-payment of rental debt that accumulated due to COVID-19 hardships, all the following shall apply. So my answer is yes, but so long as the rent that's now owed to you is due to COVID-19 hardship.
Next question is, are late fees considered part of rent due? Can a landlord apply for the late fee as rental assistance?
Now, that's a great question. I don't, I'm unsure. My legal mind is telling me no, because late fees are not considered rent generally, and you can't even evict for non-payment of rent if you put late fees in the notice of termination of tenancy. Late fees are never considered rent. So my answer to you is going to be, it's very unlikely that a governmental agency that's set up to help tenants maintain housing by paying rent will pay a fee or any kind of thing that's other than rent. So very unlikely. But who knows? These agencies might be set up differently across the board. Perhaps one does things differently than the other. But I would assume that you would not be able to get late fees in that.
Okay, this might be kind of sort of that previous question. Is the AGA increase considered part of the rent due?
If you took a rent increase, I'm kind of unclear, but I will answer this like this. If you were entitled to a rent increase, and in fact, you availed yourself to that rent increase, meaning that you've served the tenant with the notice and you were lawfully entitled to do that, there was no moratorium prohibiting you from doing that, or no local law or prohibiting you from doing that, then it's no longer an AGA, it's just your rent. The rent has gone up, and whatever rent is owed is owed.
Okay, the next question is, if the tenant fulfills 25% of the rent owed, when is the next due of the remainder of the rent owed?
Okay, that's a great question. So if the tenant has done the 25% owed, what I said earlier, and I'll say it again, you cannot evict for the remainder owed that's related therein, right? That the only way you can seek that money is through small claims court. And your landlords are going to be permitted to go to small claims court on debt owed starting November 1st. But in terms of going to court and evicting the tenant based on rent owed, where 25% was that portion of that rent, landlords are gonna have a very difficult time overcoming that defense. So you might want to check in with an attorney to weigh your legal options there. But you can seek the rest of that money through small claims.
Okay, the next question is, I have a renter who is a senior in her early 80s. She says she can't afford the 4.5 CPI increase. Is there a way she can get help from the state so I can gain the CPI?
Well, if anyone, not even, because I don't answer specific questions, remember, so it's a lot of detail, but I'm just going to pretend like I didn't see it. If anyone is having problems paying rent for whatever reason, then they can certainly seek rental assistance. Before COVID hit, there were rental assistance programs around, Catholic Charities and Seasons of Sharings, for instance. It was it was far less funded than it currently is because of the current conditions we're living under, but they had some funding. So whether or not there's funding at the state level or local level for non-related COVID-19 issues, I'm unsure of, but I can tell you that prior to COVID, there were those things. So I would certainly look at our resources, or you can certainly call in to our program or email a staff member, and we can forward you those resources. And I would definitely look into that. I'm by no means am I an expert around these issues. She might qualify for other services given her age and if she has any kind of disabilities. So I would, you may benefit from speaking with the housing counselor here at the program, and hopefully coming up with some ideas to help this individual.
Okay, another question. Wait, so Charles, this person is saying your name. You're saying that the council made the active decision to exclude non-payment of rent from the city moratorium. And then the next part is, a council member and an attorney who work on Richmond's moratorium told me that AB 832 blocked them from including local protections for non-payment.
Oh, so that might be the case. I don't work on that side of the city. What I was saying is these decisions that are made typically at the council level or at the state legislator levels are typically political decisions, and that they are oftentimes revisited, right? And sometimes things that weren't done prior are done subsequent and vice versa. So I wouldn't really rest easy. I would just keep listening to things happening. I don't know what the city council's basis is or the attorneys. So you may be absolutely correct and I might be absolutely incorrect there. But just be aware that other cities have done it, and the state law applies to every city. So, I'll leave it at that. I don't know though. So you might be correct, whoever asked that question.
The next question is, our tenant applied for the tenant relief program last month, but did not send a 25% rent payment. Is it too late to give a declaration?
So today is the last day to, I will say this, where a landlord, the law is never clear cut. You go into court, you think you have everything, and there's equities that need to be balanced. And I can't tell you how a judge will look at that scenario. What I will tell you is that the law says a landlord or a tenant has to put their landlord on notice that they have this COVID-19 financial distress issue and pay the 25%. Now, in order to avail themselves to those benefits of not being able to be evicted on that debt. Whether a tenant has done that or not, it's a question of fact. I'm not going to get into, whether or not an oral statement or a statement that's not on an official form will qualify as a declaration, or that or whether or not a rental assistance payment can stand in the place of a 25% payment. I have no idea. I'm not going to go down that road because that's extremely legal in nature. So I would encourage you to, if you have facts like that, I certainly would encourage you to speak to a legal counsel. And like I said earlier, and I'll say it again, we do have a referral service. And if you qualify, you could receive free legal advice, and you can certainly ask those questions.
Okay, another question. If government disapproved rental assistance for my tenants, does that mean I can start my eviction process?
Again, I'm not going to answer your specific question. I will just generally give you this information. Can you go to we're already on the slide.
Yes.
Okay, it says that if you're going to evict a tenant starting October 1st until March of next year, March 31st of next year, you got to do one of the following. You have to attach a statement or file a statement verifying under the penalty of perjury that the landlord completed an application for rental assistance to cover the rental debt demanded from the tenants in the case, but the application was denied. Okay, so you have to attach that statement to your unlawful detainer complaint that you filed for the rental assistance, that the rental assistance was denied, and you have to attach a copy of the final decision from the agency, from the pertinent government rental assistance program denying a rental assistance application for the property. So whatever final order you received, you have to attach. And I'm just going to be clear here. This is the law is very specific as to what a final decision means, and you should look it up or consult an attorney, or actually you can even come into the housing rent program for information on it. So not all decisions are considered final, but there are some that are. I hope that answers your question.
And just know we will have these, we'll have the recording of the webinar as well as the PowerPoint on our website. Okay, we have another question. Does the Richmond rent program track how many units in Richmond rent control let me read it again. Does the Richmond rent program track how many units in Richmond are claiming they need rent relief? And if so, what percentage is that of the total number of rent control units? I think this is important because if the city has a high number of people seeking rent relief, this could have a major impact.
Yeah, I'm not sure. It's a good question. I'm not sure because I don't work on that side of the program, whether or not these things are being tracked. I do know that there are rental assistance agencies that the rent program works in tandem with. Our executive director sits as one of the members of the agency. And I do know they keep record as to how many applications they've received. But if a landlord applies for rental assistance, they do not apply through our program. And likewise, if a tenant applies for rental assistance, they do not apply through our program. So there's really no way we would know whether or not they've applied unless they tell us. So I think that information is likely being held by the agency that's receiving the applications, because they obviously know who has applied. Is there any questions from the Spanish speakers? I know there might, I'm not sure if there's a way to type in the chat for those who only speak Spanish, but were there any questions from them?
The interpreters are still interpreting, so I guess they can ask that question.
Okay.
But we don't have any questions as of now. Oh, one more, I have another one. For rental assistance program, does both landlord and tenant need to apply separately, or can tenants do it themselves?
That's a good question. I'm unclear because different programs require different things, obviously. I know though that the law, a part of the law points out that if a tenant fails to provide the information that's necessary to complete an application within 15 days, then there's an adverse impact on the tenant. So the law does recognize that some agencies may require both landlord and tenant fill out an application and there make both parties responsible. So so a tenant can't, not fill out their portion and so I'll leave it at that. But can you go to slide 18? Okay, and just to answer, just to put a button on it, slide 18, whichever option the landlord chooses, when serving the tenant with the unlawful detainer, the landlord must serve the tenant with copies of the statement and final decisions that were filed with the court. And so to prevail in court, the landlord carries the additional burden of proving that they applied for rental assistance and that the landlord's application for rental assistance was denied because of lack of eligibility, lack of funding, or the application remained incomplete due to the tenant's failure to properly complete the portion of the application that is the responsibility of the tenant for 15 days. So again, if the rental assistance program requires tenant information and the tenant is the only one who can do that, well, this law right here accounts for that, right?
Okay, and the interpreter said they did check to see if there was any questions, and they are going, if they have any questions, they'll put them into the chat box.
Okay.
So far, we are just awaiting and see if we have any more questions. As of now, we don't have, oh, hold on. So someone did ask, they did ask a question in Spanish. Oh. Tatiana, can I unmute you to say the question? Tatiana, can you speak? I don't know if she's able to speak to to say it because okay, just letting them know they can ask here. Oh, okay. No one, okay, no, once we assign, okay, got you, okay. She says she's just letting them know right now that they can speak in the chat. Okay, I'm sorry, I thought it was a question. All right, well, so far, Charles, we have no more questions right now, unless you wanna wait a few more minutes.
Yeah, I'll give.
Interpreter did put in the chat that if anyone, she wrote it in Spanish, that if anyone has a question as well, that they can write their questions here. And so far, we have no more questions as of now.
Sure. I started a little late, so we'll give it a few more minutes, and if not, then that's okay too.
If anyone else has a question, please drop it into the Q&A section of the at the bottom of your screen. We'll be here for a few more minutes if you have any other questions.
And for those of you who are still on, I think it's our intent at the Richmond Rent Program to try to do a joint presentation with one of the rental assistance program providers, so that you can all actually, I know a lot of these questions are going to turn on information that I don't have because I'm not a provider of rental assistance. And so hopefully that will be helpful to all of you. I'll just give it 2 more minutes, and if I don't receive a question, then we can end.
And let me just say I'm going to repeat again that this PowerPoint presentation will be on our website under the workshops tab on our workshops page. And also you will be able to access this PowerPoint and download it for reference. We do have another question. I'm sorry, but I think someone asked this, but I want to know if a landlord can impose a rent increase after September 30th.
Yeah, don't apologize. It's okay. Yeah, so the county moratorium expires today, and that moratorium covered rent increases. And the city of Richmond currently does not have a rent increase moratorium, meaning there is no longer, after today, there's not going to be a suspension on rent increases. Now, whether or not an individual landlord can increase the rent, I have no idea. It depends on whether they are in compliance with the law, whether that be local law or state law. But there is no longer a moratorium. As at the end of the day today, so October 1st, there will no longer be a moratorium. on rent increases. But as I've mentioned before to all of you, be aware things can change very fast. The city of Richmond can take up issues however they see fit. And so I want you all to just be aware of that.
No more questions right now. The time is 2:35.
Okay, so I want to thank you all. I want to especially thank the interpreters. I know I was speaking really fast. I apologize. Thank you for your time, and thank you all for tuning in. I hope it was helpful. And if you want to hear any other topic that you think is important, feel free to shoot the rent program an email, and we can tailor these things to whatever you like to hear.
Thank you. And again, this webinar will be posted on our workshops page, as well as the PowerPoint that you can use for reference. Thank you, everyone, for attending.